Hello everybody, welcome to this episode of Courts This Week on LiveLaw. I am Taniya Pandey and it's time for our weekly court updates. Let's begin with the Supreme Court first. The Supreme Court has extended the limitation period for the filing of cases in courts and tribunals with effect from 14th March 2021 until further orders in the wake of the second wave of the COVID-19 pandemic. The period from 14th March 2021 will stand excluded from computing the limitation period under all special and general laws. The bench of Chief Justice of India, N.V. Ramana, and Justices Suryakant and A.S. Bopanna extended all periods of limitation ending on 14th March 2021 until further orders by restoring the order passed on March 23, 2020. The Supreme Court has reiterated that it is necessary for courts to consider the impact on the witnesses and victims in a criminal case while granting bail to an accused. The Supreme Court made this observation while setting aside an order of the Allahabad High Court which granted bail to an accused who was arrested under the UP Gangster and Anti-Social Activities Prevention Act 1986. The accused was alleged to be a contract killer and sharpshooter. Challenging the bail granted by the High Court, the widow of the deceased approached the Supreme Court. The Supreme Court observed that the High Court had overlooked several aspects, such as the potential threat to witnesses, forcing the trial court to grant protection. The most precious fundamental right to life unconditionally embraces even an under trial, the Supreme Court observed while directing to shift Kerala journalist Siddique Kappan from Mathura jail in Uttar Pradesh to a government hospital in Delhi for medical treatment. This order was passed in a habeas corpus petition filed by Kerala Union of Working Journalists seeking Kappan's release. After his recovery, he has to be sent back to Mathura jail where he is under custody in a UAPA case on the allegation that he was trying to create communal unrest in UP after the Hathras gang rape murder crime, the court ordered. The Supreme Court, while issuing directions to reduce delays in the execution proceedings, observed that an executing court must dispose of the execution proceedings within 6 months from the date of filing, which may be extended only by recording reasons in writing for such delay. The bench, headed by the then CJI S.A. Bobde, asked the High Courts to reconsider and update all the rules relating to execution of decrees made under the exercise of the powers under Article 227 of the Constitution of India and Section 122 of CPC within 1 year of this order. The court also issued multiple directions which would remain enforceable until such rules are brought into existence. The Supreme Court has issued guidelines to make the criminal justice system more disabled friendly. The testimony of a prosecutrix with a disability or of a disabled witness for that matter cannot be considered weak or inferior only because such an individual interacts with the world in a different manner vis-a-vis their able-bodied counterparts, the bench of Justices D.Y. Chandrachud and M.R. Shah observed. The bench was considering the appeal filed by the sole accused being tried for the offences punishable under Section 376 subsection 1 IPC and Section 32V of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act for committing rape on the victim girl who is aged about 20 years and blind by birth in her house. The High Court had affirmed the conviction of the accused by the trial court on these charges. The Supreme Court finally set aside the conviction of the accused under Section 32V of the SC/ST Act, but upheld the conviction and life sentence punishable under Section 376 IPC. The court also doubted earlier judgments, which interpreted Section 32V of the SC/ST Act to mean that the offence should have been committed only on the ground that the victim was a member of the scheduled caste. To deny the protection of Section 32V on the premise that the crime was not committed against an SC and ST person solely on the ground of their caste identity is to deny how social inequalities function in a cumulative fashion, the court said. The Supreme Court has dismissed the applications filed by certain banks seeking to recall the 2015 judgment in the case of Reserve Bank of India versus Jayantilal N. Mistry, which had held that the RBI was obliged to disclose the defaulters list, inspection reports, annual statements, etc. related to banks under the RTI Act. A bench of Justices L. Nageshwar Rao and Vineet Saran dismissed the applications, observing that the Supreme Court rules did not have any provision for filing of application for recall of judgment. However, the bench has given liberty to the applicants to pursue other available legal remedies against the Jayanti Lal Mistry judgment. The Supreme Court has reiterated that minor contradictions cannot be a ground to discredit the testimony of a witness in a criminal trial. The court was considering an appeal filed by the accused who were convicted for the offences under Section 302, read with 34 IPC and Section 135(1) of the Bombay Police Act. In appeal, one of the contentions raised by the accused was that there are major contradictions in the deposition of two prosecution witnesses. While dismissing the appeal, the bench observed that omissions like not seizing the motorcycle and also not seizing the gold chain of one of the victims by itself is no ground to discredit the testimony of key witnesses who were examined on behalf of the prosecution, whose say is consistent, natural, and trustworthy. The Supreme Court has held that the scope of subsection 5 of Section 80IA of the Income Tax Act is limited to determination of quantum of deduction under subsection 1 of Section 80IA of the Act by treating eligible businesses as the only source of income. In this case, the assessing officer restricted the eligible deduction under Section 80IA of the Income Tax Act to the extent of business income only. The Commissioner of Income Tax Appeal 1 partly allowed the appeal filed by the assessee and reversed the order of the assessing officer on the issue of the extent of deduction under Section 80IA of the Act. The Income Tax Appellate Tribunal upheld the decision of the appellate authority on the issue of deduction under Section 80IA. The High Court refused to interfere with the tribunal's order as far as the issue on deduction under Section 80IA is concerned. While dismissing the appeal, the bench of Justices L. Nageshwar Rao and Vineet Saran observed that subsection 5 cannot be pressed into service for reading a limitation of the deduction under subsection 1 only to business income. Benefits flowing from the Assured Career Progression Scheme and the Modified Assured Career Progression Scheme are incentives and are not part of the pay, the Supreme Court has observed. The court allowed the centre's appeal against the Delhi High Court direction to grant the second financial upgradation to the employees under the modified scheme with effect from 1st January 2006 by relying upon a judgment in Union of India and Others versus Balbir Singh Tern. The court also agreed with the centre's stand that uniform implementation of MACPS for civilian employees with effect from 1st January 2006 would result in large-scale recoveries of amounts paid in excess. While deciding a criminal appeal on merits, the High Court is required to apply its mind to the entirety of the case, including the evidence on the record, before arriving at its conclusion, the Supreme Court has reiterated. The bench of Justices D.Y. Chandrachud and M.R. Shah made this observation while allowing an appeal against an Allahabad High Court judgment which reversed the conviction of the accused by the trial court. In this case, the accused was convicted of the offence of kidnapping under Section 364A of the Indian Penal Code and was sentenced to undergo imprisonment for life, to a fine of Rs 5,000 and in default to undergo imprisonment for a period of 1 year. The trial court judgment was set aside by the High Court by allowing the appeal. The state therefore approached the apex court. Perusing the judgment, the bench noted that there has been no independent evaluation by the High Court of the evidence or of the submissions which were recorded by the High Court. The court relied on the recent decision in State of Gujarat versus Balchandra Lakshmi Shankar Dave and observed that the Court of Appeal has wide powers of appreciation of evidence and the High Court has to reappreciate the entire evidence on record, being a first appellate court. Now it's time for the important High Court judgments. following orders quashing rape and child sexual assault charges against various accused. Justice K. Haripal of the Kerala High Court, in a special sitting on 28 April, suo motu recalled 3 of his orders, where the cases were quashed on the ground of the marriage of the accused to the survivors. Justice Haripal remarked that he had not noticed the decision of the Supreme Court in Gyan Singh v. State of Punjab and subsequent cases when issuing the earlier order. In Gyan Singh, the Supreme Court had held that heinous and serious offences like murder, rape, and other such offences could not be fittingly quashed, even though the victim or victim's family and the offender have settled the dispute. The Allahabad High Court has taken judicial notice of the death of 135 persons who were on election duty during the Panchayat elections in the state due to COVID-19. It appears that neither the police nor the Election Commission did anything to save the people on election duty from getting infected by this deadly virus, a division bench of Justices Siddharth Verma and Ajit Kumar sternly observed. The matter of death of 135 teachers, Shiksha Mitra and investigators who were posted on election duty during the recent phases of Panchayat elections came to light by way of a news item dated 26 April 2021, published in News Daily Amar Ujala. After verifying the news, the court took judicial notice of the incident. Justice N. Anand Venkatesh of the Madras High Court on 28 April remarked that he is not fully woke to the concept of same-sex relationships and that he will undertake an education session with a psychologist to understand the same. The development happened during the hearing of a protection plea filed by a same-sex couple. Significantly, the judge had earlier asked the couple and their parents to undergo counseling in order to understand each other better. That's all for this week. I hope you're all staying safe and healthy. I am Taniya Pandey, and I'll see you soon with more updates. Have a peaceful and beautiful week ahead.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.